आप स्टार्ट कर दीजिए।
Akshay, am I audible?
Yes sir, you are audible.
Fine. Thank you. Thanks, Vaibhavi. Thanks for the introduction. And yes, I request participants to turn off the mic because unnecessary interruption in between may break the flow. So, if you have any doubts, any discussions, we can have it uh, in the chat box. You can post your queries. You can ask after topic is discussed. Okay. So, good evening, guys. I'm Gagandeep. I'm a practicing advocate, and I have interest in family law. No, it's a very big term, family law, which includes various laws like divorce, maintenance, adoption,
मतलब फड़का एग्जाम
guardianship. So, yes, uh, guys, again, it's a request that please turn off your mic because it will be very awkward for us while presenting. And please, it's a request. Kindly turn off your, I mean, mute your mic so that there won't be any disturbance. Yes, taking from there. So, this law of divorce is a very big topic. Law of maintenance, it's a very big topic. And it comes under another big topic that's a law, a wing of law. We say family law, right? In our LLB um days, we have come across this uh, subject called as family law. And I guess there are fellow advocates who are practicing who are also in this webinar session, and there are students also. I know that you may take up this subject in your coming days in your law school, and some people might have read, some people might have come across judgments of Supreme Court and your native High Court saying that if your wife comments something about your color, so it becomes cruelty. Or some, no, you come across some social media platforms, there'll be, some posters on this legal news. So if wife does this, if husband does this, this is cruelty, and so on. Yeah. So there are various examples. Taking it from there, so now we'll confine our topic under law of divorce to Hindu Marriage Act Section 13. Okay, so under Section 13, there is this concept called as divorce. What is divorce? So, guys, nowadays in metropolitan cities, the ratio of divorce, I mean, the divorce rate has been exponentially increased. So, why I'm saying this is because I also practiced before family court Bangalore aftermath of COVID. So when there was relaxation, few fellow advocates as well as the clerks who were working in family court Bangalore used to tell that after the COVID lockdown got relaxed, so there was so much of divorce petitions filed before family court, mutual divorce petitions. So why is this happening? Day by day, the divorce petitions, the matters are increasing exponentially. The graph is not coming down, it's going high. Why? So was divorce not there
यहाँ
in
तक
the
की पानी
early days?
मधु
Uh,
भाई यहाँ तक की पानी
so
Please
yeah,
mute your mic.
yeah, this happens and okay. So taking it from there, See, in early days also divorce used to happen, but not that much. No, the rate was very less. Now, this generation, there's a rapid increase in divorce cases. So, no, there are various reasons for this, especially in metropolitan cities and I mean metropolitan cities like Bangalore, Mumbai, Delhi, Chennai. The rates are increasing. It's and I would also say that in other cities also the divorce cases are there, but compared to metropolitan cities, it's less. This is due to because nowadays both husband wife they earn they work. There are ego clashes, okay, and the matter because I being a practicing advocate, I know the reasons why people come to us and file divorce petitions. One will be because of ego clashes, and second will be because they'll be having affairs. So this is a very no disheartening, and it's a very big problem when it comes to divorce because either wife or husband, so they'll be they'll be running some affair with some other lady or some other person, and this happens. And third is domination, and fourth is because see these people, there's a concept called as arranged marriage. So what exactly is this arranged marriage? How does this things work? What happens? So you meet a girl, see, and you see the family. You don't know who that girl was in the past, what she does, nothing, and suddenly family says it's a very good, tie up. You should, have. You should think about this. That once they get married, they will be having so much of problem because the the lady, her family, her how she has grown up from her tender age, and how this person husband, how he has come, what background, what family, and how he has grown up from his tender age, everything matters. So once you know uh, you'll be having a husband will be having a strong opinion, and wife will be against that. These things uh, start having, and there'll be a clash. So this clashes, it goes on, and finally it reaches to the stage where the relationship will be very bitter. Once it becomes bitter, uh, the first thing what happens is, as I see in the society as an advocate, we'll approach our family elders. We say that mama, this is a problem which is going on with my wife. So what to do now? There'll be in almost all of the cases before we approaching family court, there will be some reconciliation thing. There'll be something called as panchayat, where both the family side elders they sit and they talk only with the purpose to uh, reconcile and tell this both husband and wife to have a happy life, compromise some things. This thing happen, and even after this conciliation or reconciliation efforts made by both the family side, it doesn't work. I think someone's mic is on. Kindly mute them. Fine. So yes, taking it from there. So uh, even after the reconciliation thing won't work, people come to the lawyer's office. They go to the advocate's office and they say, "Sir, this is the problem which I am facing." Uh, they say, "Sir, we'll send a legal notice." The first step uh, in this process of getting a divorce is sending a legal notice. So in that legal notice, you will write that what problem you faced from your wife or husband, and you draft it in a very, using that all legal words, and you send it to your wife address. Okay. So in that, you may also write that we'll settle this dispute amicably, calling your wife to talk will settle this out. Or if you are thinking of uh, ending this marriage by a mutual divorce, so you'll send it in the legal notice itself that you are intending to end this relationship by sending a legal notice through mutual divorce. So whatever your intention it is, so everything starts with the legal notice, if you ask me. Okay. So once that legal notice is delivered to your wife or husband, then the next process will be they'll reply for that legal notice. So in your legal notice, you say that you should reply by 15 days. So you wait for that 15 days. If there is no reply, you will proceed to file divorce petition. So proceeds to file divorce. Okay. If there is a reply, looking into that reply, you proceed towards filing a divorce petition, right? So, okay. Now, if you allow me to share the screen, I would show how the legal notice looks like. I know this is not a drafting session, but still, I would like to, show the draft of legal notice, how it looks. Akshay, if you are there, can I share the screen?
Yeah, you can.
Fine.
ஆகாய சூரியனே ஒற்றை குட்டி
So, can you guys see this notice?
Yes, sir.
Akshay, yeah, okay, fine. Thank you. So sorry, there is some scribbling. So this was the reply notice which we had sent to one of the notice. Actually, wife had sent a notice to our client. So for that notice, we have sent a reply. So this is called as reply notice. So as I told, this is a first stage. Formally when divorce, if you think of getting divorced, so this is how you draft a notice in this way, and this is how we send it through registered post. So yes, so this I wanted to show you. This is how the legal notice looks like. Fine. So if you guys want, I would also share the draft of legal notice to the organizer actually. So you can collect it from there.
Let's continue.
Yes. So yeah, taking it from there. Okay. Definitely, I'll be sharing the draft of legal notice, both legal notice as well as reply notice. So after this process of sending legal notice and reply notice, we will proceed to file divorce petition. So everyone knows that under which I guess most of you guys know under which section we file divorce petition. If the husband and wife are Hindus, right? Our discussion for today's topic of law of divorce would be confined to section 13 of Hindu Marriage Act. So if you read section 13 of Hindu Marriage Act 1955, so there are various grounds under that section. Fine. So say for example, a client comes to you and he says or she says that, sir, my husband or wife has left home and he or she has not returned back. It's been 3 years, it's been 4 years, it's been 5 years, six. So this is a very good ground for desertion. We call it as desertion. So if I read this section 13, so it says under section 13(1)(b) that uh, any marriage solemnized whether before or after commencement of this act may on a petition. So as I told, we'll be filing a divorce petition under section 13 by either husband or wife. So it's if husband is a affected party or wife is a affected party, so one person will be filing the divorce petition. Be dissolved by a decree of divorce on the ground that the other party has deserted the petitioner for a continuous period of not less than 2 years immediately preceding the presentation of the petition. So what does this mean? So today the husband thinks or the wife thinks that she wants to file a divorce petition under this section 13 on the ground of desertion. So what is that essential ingredient? That essential ingredient is that before filing that petition, there should be a separation between a person who is intending to file that petition and be it husband and wife. So the separation should be more than 2 years. So that's a statutory period under section 30 of Hindu Marriage Act. So this is very important. So recently, I was appearing for a respondent, and the petitioner was husband, respondent was wife. Husband had filed a petition under section 13(1)(b), that is desertion, under the ground desertion. So how important the pleadings in the petition should be? That when I read his petition, so in the petition himself, he himself has mentioned the cutoff date, that is from April 2021 to some month somewhere in the year 2023. So he says that the respondent left the home in the first week of April 2021, right? So he had filed the divorce petition in the year 2023. So I saw the date of petition. So from the date of petition to whatever the period is mentioning that the wife left home, the statutory period, it doesn't meet at all. So there was no separation between husband and wife, that is the petitioner and respondent, for the period of 2 years, right? So, as I told, the statutory period for desertion is 2 years. So this is one of the ground. Next, we'll go to the another ground, that is the common heard ground everywhere. Wherever you read regarding legal news, divorce, that is cruelty. So this cruelty, uh, you know, uh, the Supreme Court, High Court has interpreted in many different ways. So in cruelty, there are two kinds: physical cruelty, and you call it as mental cruelty. Nowadays, another cruelty has taken place, that is emotional cruelty. So as generation changes and uh, the problems which are coming up before the courts, while interpreting, they are giving it a terminology. So they are naming it. So recently, when we filed a petition, it was on the ground of emotional cruelty. So we file it on mental cruelty. We file it on physical cruelty, or in the petition, there will be both physical and mental cruelty, as well as emotional cruelty. So the simple facts in the petition will be like this: that my husband, that is the respondent, he constantly hits me, he assaults me, he abuses me in front of everyone, and he tortures me a lot. He taunts me for everything. See how these various forms of cruelties. Uh, Once you write it in the petition, the second part will be proving it. How will you prove cruelty? So for that, once you file the petition, the procedure will be once the notice is issued to the respondent and respondent comes to the court, appears before the court, the matter will be referred to mediation. In mediation, what it happens? There'll be a mediator, husband, wife, both petitioner and respondent. They sit and talk. If things work out, they'll settle it there. If things doesn't work out, the file will be again sent to court has mediation failed. So there the case will be posted for objections. If petitioner has filed the petition, objection will be filed by the respondent, and after that petitioner evidence commences. So this is where there is a huge burden on you to prove your case by giving solid evidence. For example, your husband has hit you, or your wife, be it husband or wife. Nowadays, even wife hits husband. These cases are common. So if you are saying that you have filed this divorce petition on the ground of physical cruelty, it depends on how best you provide evidence. I mean, be it documentary evidence or anything, any oral conversation, any recordings, or if you say that your husband is having affair, the WhatsApp chats and his email correspondences with some person. So these are all the materials which are very important to prove your case. Just because you say that my husband hits me, what is the proof? What is the evidence? So that becomes very important factor. Few people come to us, they say that, sir, my husband hits me. Okay, have you filed any complaint before the police to prove that your husband used to hit you? To show that you had filed a complaint? No. So you say that your husband has affair. Do you have any material to prove that your husband has an affair, like WhatsApp chats, email correspondence? No. Okay. You say that your husband has left home. He has not returned back. It has all 2 years has already passed. So how do you prove it? So you should be having that materials, right? Or in cross examination, you pose a question to the husband or wife. You ask a question. Say for example, I put it to you in this way, that you had left your home, or you were residing with your wife at this home. Yes, he says, I was residing at this time with my wife at this home. and okay, and you left that home so and so date. If he doesn't remembers the date, you can also mention month, year, to make him at least tell in which month, in which year he left. So in cross examination you get few admissions where those admissions support your case. This is how you prove your grounds which you have urged in your petition. So if you ask me, uh, when you start practicing family law, especially divorce and maintenance, you should always suggest your clients to have a solid case and solid evidence so that you could do justice to your client. And there are few tactics how to obtain, for example, I learned this skill when I was with my senior. There was this maintenance case filed by a wife. She says that we'll discuss about that maintenance also. She says that she wants maintenance under section 125 of CRPC from her husband. We represent husband. So these tactics are like this. Actually, wife is also a CEO of a partnership firm which is running. This works for the body dieting and weight loss management. So what happened? You know how legal mind runs, how best our advocates are, how innovative they think. This is a very good example which I'm giving. So the respondent came, that is the husband, came to our office, sir, what to do? And we told that, see, to prove that your wife is working, what are the materials you have? He told, sir, nothing. Okay. We told, do you follow your wife on social media? Yes. So she was, into this business of weight loss management and dieting. She posted that she, on so and so day, there's a poster, it says that she is having these sessions of weight loss management. Okay, we got a screenshot of that. Then this person, we suggested that this respond, that is husband's friend, should go to their clinic. So he sent his friend to the clinic. He consulted wife, I mean his friend's wife, that is husband. He consulted his friend's wife, and he has got a prescription where there is petitioner's sign. uh, Say, and she has written that you should follow this diet, and this is how you should manage your weight, everything. So this petitioner was called for cross examination. On that day we got that prescription. This was very interesting. We took that prescription and we showed it to the petitioner, that is the wife, saying that, see, look, this is your company which you are working, this is the prescription which you give. She says yes. She has confronted that document. So one purpose is that my main purpose was, she was working, she is also financially stable. She agreed yes. So she's working woman. Second, she has a business. So this is how lawyers must think innovatively. Or if you are law students, you should start this skill of thinking innovatively. This is how you can give justice to your client. This was one such example. There are many examples where we can think innovatively and we can save our client. This maintenance has become literally a business, because after this divorce, uh, we'll discuss about that, looking into the time constraints. Now first we'll discuss about this grounds. The next ground is adultery. Okay, so adultery was actually under IPC, it was declared as unconstitutional by our apex court, but still it survived as a ground for divorce. So that's one ground wherein you can file a divorce petition. And the next ground may be, if wife or husband is an unsound mind person. So that would be uh, uh, a good ground for divorce. For that, again, you should again prove that your wife or your husband is a unsound mind person. So this again proving becomes very important task. Only just because you file your divorce petition, that does not uh, uh, makes you to get relief from the family court. Proving is again the different task, or we can also call it as challenge. So and if a husband or wife is having a disease which cannot be cured, for example AIDS, so and some communicable diseases, so you can get a divorce and that on that ground. So these are various grounds under Section 13 of Hindu Marriage Act 1955. We file many petitions daily. It has become a task for us. We file many petitions. The common grounds are desertion. On these grounds, we file divorce petitions, and some few, it's very rare that people come to us and they say that, sir, my husband or wife has converted into some other religion. So again, if your husband or wife is converted to some other religion, that is also a ground for divorce under Section 13 of Hindu Marriage Act 1955. So the time has changed, and the grounds of divorce uh, have also developed by interpretation of Supreme Court as well as high courts, jurisdictional high courts. It has made somewhere that the party should not be suffering. Take for example, under Section 13B, there's a concept called as mutual divorce, where both the parties, that is husband and wife, they come together to the family court to end their matrimonial tie by way of mutual consent. So recently, if you read Section 13B, there was a cooling period. You should at least wait for 6 months, and that period should not exceed 18 months. So 6 months stuck. What was the purpose of Section 13B was you should give some opportunity to husband and wife so that there'll be chance of some reconciliation. Now the time has changed, and there's so much of development that IA under Section 13, interlocutory application under Section 13B, clause 2, saying that you can waive off the cooling period, that is the waiting period. 6 months waiting period can be uh, cooled off. That is, that cooling period may be waived off. So it can be waived off. So you should, convince the court that these are all the circumstances we have already agreed. Kindly refer this matter to mediation. Then what judge does is he refers matter to the mediation. There you go, there you sit, there you arrive at an amicable conclusion. You'll draft a memorandum of settlement. You'll read terms that if you are having child, in whose custody it should be it wife or husband, and visitation rights. Everything will be discussed. That is how things happen at mediation. So after that, that memorandum of settlement will be sent to family court back, and then judge orders, and finally you'll get your decree of divorce, that your marriage with your wife or husband has been dissolved on mutual consent. So this is how the law with respect to divorce
Daddy,
changed, and it has
serious
emerged.
See.
Kindly mute, someone is talking. Fine, thank you. So this is how the time has changed. So taking it from there, say for example, now the husband and wife is a Hindu. Now husband and wife, I'll give you an example, not confuse you. Husband is Hindu, wife is a Muslim, or husband is Hindu, wife is a Christian. So for this, whether Hindu Marriage Act 1955 applies? No. There is something called as Special Marriage Act. So under Special Marriage Act, you should file a MC petition, matrimonial case petition under section 27. Again, there are grounds, and if you read section 27 of Special Marriage Act, if in case the husband is Hindu or wife is Hindu, the respondent will be some other religion. So there, the Hindu Marriage Act won't apply. Their Special Marriage Act will apply. And again, there is a concept called as divorce. There are these grounds which we discussed right now: desertion, cruelty, some communicable diseases which cannot be curable, unsound mind person, everything. So there are the grounds are there. The concept called as mutual divorce is also there under Special Marriage Act. So this is the law of divorce with respect to Hindus, Hindu Marriage Act. And if in case it's a Hindu and other religion, I told the Special Marriage Act applies and it comes into the picture, and you should file a petition under that. So I'll not get into the procedural aspects. So I'm just giving you the rough idea, because at least if some person, if you are a law student, if your neighbors or someone is facing a problem, you people should be in a better position to guide them, because you are studying law. That's your duty. uh, we are, we work in grassroots levels, and our aim should be to do some justice, because we are studying, and we are in a very noble profession. So you should have this idea: what is legal notice, what is reply notice. So if in case uh, the husband and wife both are Hindus, section 13 of Hindu Marriage Act comes into the picture. And if someone says you their problem, under what ground they can file petition before family court. So this, you should have some clarity in your mind, that you should be in a such a way to suggest them, support them, educate them. So this should be our work, right? So again, if in case, as I told, if wife is Hindu, husband is some other religion. If husband is Hindu and wife is some other religion, you should be in a very good position to say that Hindu Marriage Act does not apply, but Special Marriage Act applies. Again, you should ask what is the problem, under what ground their case fits. And this is how, you should develop your legal acumen with respect to law of divorce. So this was my purpose of today's topic, because divorce is a very big topic. It's a vast topic. If we get into the case laws, again, the literature which the Supreme Court and High Courts have developed is vast. So in specific, if we have a webinar in future days, we'll deal with case laws. But I just wanted you all to have a better picture what divorce is, how it happens, what is mediation. So with respect to procedural aspect, keep this thing in mind, that first you approach to an advocate, you go to an advocate's office, you tell about your problem, your advocate drafts a legal notice. It will be posted, it will be couriered to your, the opposite person, that is husband or wife's address. If there is any reply, they'll write their own, case, their own story in that reply notice. And next, what is the step is, you'll be filing a petition before family court. So with that family court petition, uh, you are supposed to present before the family court the very first day, and then the notice will be issued to the opposite person, that is wife or husband. Once the notice is served to them, once the notice is received to them, there will be a date written in that notice saying that you are supposed to appear before family court on so and so date. If he does not appear, he or she will be placed ex parte, that is, in his absence the entire proceedings will run. So if he appears or if she appears, first step what family court does it's a compulsory procedure which family courts have adopted, that the matter will be referred to mediation. Husband and wife go, they together they go to mediation center, and they sit and talk. No, we daily see in the family courts, they scream, they shout, there'll be some arguments, some clashes which goes on, saying that I have given so and so money to this person. If he's ready to give that money with permanent alimony for my life, I am ready to end this matrimonial tie. There'll be negotiations which goes on in mediation center. If you are law students in your internships, please do your internships. If you want to get an experience with respect to mediation and this entire divorce and family court practice. Family court practice advocates, you can go to their office, apply for internships, and you can get this first-hand experience of how mediation happens in reality. Seeing it in the picture is different, or I mean the films is different, and seeing it in reality is different. No, and BCI allows the law students to do their internship and to get first-hand experience about our profession. Use that as an opportunity. Uh, After mediation, if the uh, case is settled there, there'll be a memorandum of settlement drafted, signed by both the parties, and sent back to the court. And court passes a order that on this memorandum of settlement, the marriage between so and so is dissolved. In case in mediation, if the matter is not settled, the report comes to the court back saying that the mediation has failed. So you can ask me one question, sir. Once the mediation report comes to the court back as failed, can we again go back to mediation on after few days, after few months? Yes, court will not stop you. Court won't tell you that you can't. You have already gone once, and second time you can't. So n number of opportunities will be given in one of our officers' case. So 17th time the matter was settled in mediation. So 17 times both husband and wife, they went to mediation center, talks, issues, clashes, adrenaline rush was there. For us, the very challenging task was to cool the parties down. So these things happen. The beauty of practice is such that once you get into this profession, you'll also you what you used to think in your LLB days suddenly will change. Theory is different and practice is different. Okay, fine. After this mediation report comes to the court, whether it is success or fail. Success, there ends the matter. Failed, the respondent will be given opportunity to file his objections to the petition, whatever the petitioner has filed. So after objections, he has also chance of filing counterclaim. What is this object of counterclaim is? You're not supposed to file another case to prove, if you are thinking of filing another petition saying that it was your case, so you can file a counterclaim in the same petition. The very purpose is there should be no repetition of two petitions in the very same proceedings. You are filing your case. It is simply called as counterclaim. For that, the opposite party will file rejoinder. So this is another example. This can happen. Then what happens is, after objections are filed, the case will be posted for petitioner's evidence. He'll produce some documents or she'll produce some documents. It will be marked as exhibits. And once if petitioner's chief examination is over, then the stage of cross-examination will start. Now the respondent's counsel will cross-examine the petitioner, be it husband or wife. So they'll ask questions. If there are any admissions against their case, it will help respondent. And next stage will be respondent's evidence. whatever respondent has stated in objections, he'll produce some documents in support of his contention. Again, now petitioner's advocate will cross-examine the respondent. So after this evidence stage is closed, the matter will be posted for arguments. Now petitioner counsel comes, he argues his case, respondent counsel comes, he argues his case, then ultimately the matter will be posted for judgment. So that's the duty of the court, the judge, to write the judgment, and after the judgment is passed, decree will be drawn. This is how the procedure is. So if you start practicing, or if you do your internship at family courts, you will learn how things work. So listening or practicing is different. So there's a huge gap between theory and practice, that is practical. So it's my request that if you are law students, please take those internships very seriously and go to courts, get first-hand experience and see how the procedure, how parties come, how parties fight, argue, what's the issue. So you'll be in a better position once you are passed out of your law school. So you can at least, take up your own independent cases, and you start practicing the law, that is family law before family courts, law of divorce, maintenance. So this was with respect to divorce. Then comes maintenance. What is this maintenance? So as I told, for example, you have filed a petition under Section 13 of Hindu Marriage Act 1955. You say that, this is the case, my lords, under the ground of cruelty and desertion, I have filed a case. Now, what you will do? If in most of the cases, it's wife who files maintenance application. Provision of Section 24 of Hindu Marriage Act allows wife. In most of the cases, it's wife. In very rare cases, it's husband. They file Section 24 application, and they seek maintenance. What is this maintenance? During this pendency of petition, that is the divorce petition, whatever husband or wife has filed. So we are filing this Section 24 application, saying that monthly, please grant me the maintenance, that is the amount for my survival. It may include your daily expenses. It may include your traveling and litigation cost. So you should maintain. You should write everything in that application. So that is Section 24 maintenance application, which is filed during the pendency of the petition. So you say that I am unable to maintain myself. The respondent is working so and so company, is financially stable. So kindly award me some money. You say 20,000 per month. In some cases 50,000. Now what court does is, it will take that application on record. It will give another opposite party to file objection to that application. After he files objection to that application, court says file assets and liabilities affidavit by both the parties. So what is this affidavit of assets and liabilities? For example, if I file Section 24 application, for example, wife files Section 24 application, she should file assets and liabilities affidavit. What is this assets and liabilities affidavit? Is nothing but it clearly says whatever the assets which the opposite, that is her husband, has, how much is his income, and what are your expenses, daily expenses, liabilities. That's why it is called assets and liabilities. And there you undertake and there you declare that if you provide any false information, so you are you undertake that you are ready to go to jail. That is assets and liabilities affidavit. This affidavit must be filed from both the parties. So once the assets and liabilities affidavit is filed by both the parties,
यात्रेचं कुठे घ्यायचं नाही म्हणून उद्या
उद्या डेपो बंद झालं सांगा
हा, कोण आहे सकाळी
दोन डेपो बंद आहे
you
नाही नाही
this
सकाळी कोण आहे उद्या
उद्या सकाळी म्हणणार
त्यानं त्याला सांगून ठेवा सकाळी कुठल्या गाड्या आतमध्ये घ्यायच्या नाही अडीच वाजेपर्यंत कुठल्या आज गाड्या
Thank you. Okay, so once the assets and liabilities affidavit is filed, then the matter will be posted for hearing on that application, section 24 maintenance application, and then orders will be passed. That is one application or one relief of maintenance which you get during the pendency of your divorce petition. So the second maintenance regarding maintenance petition is you are going to file criminal miscellaneous petition. That is a wife files criminal miscellaneous petition under section 125 of Criminal Procedure Code, CRPC. So this section 25, if you read, 125 of CRPC. If you read section 125 of CRPC, it says order for maintenance of wives, children, and parents. If any person having sufficient means neglects or refuses to maintain his wife unable to maintain herself, or his legitimate or illegitimate minor child when married or not unable to maintain himself. No, this application, this criminal miscellaneous petition under section 125 of CRPC enables a wife to get some money for her survival from husband. So again, the same procedure as I told, petition will be filed, notice will be issued, a respondent, that is husband, appears, and he files objection, evidence, arguments, orders will be passed. So here, wife produces documents with respect to husband's work profile, his designation in the company, it may be his salary slip if she has. By producing this, she can get maintenance under section 125 of CRPC. So this is another important domain under maintenance law. Okay, so one we discuss section 24 maintenance application under Hindu Marriage Act during the pendency of divorce petition. Second section, this is different. So a different petition will be filed again. Section 125 of CRPC, criminal miscellaneous petition will be filed by wife against the husband, seeking, she wants maintenance of so and so amount, whatever it is. So third, where you can get maintenance is, it's under provisions of Protection of Women from Domestic Violence Act 2005. So what is this? So in short, we call it as DV Act. Recently, we filed one DV petition, that is domestic violence petition. Okay, so in that petition which I filed, the husband was working in Pune and wife was residing at Bangalore, and she came and she said that she wants to file because it was very terrible. The story which she said was it was very horrible, and she wanted to file that domestic violence petition before the court and magistrate court, and under that we can ask for monetary orders. If you read section if you read section 20, that is under Protection of Women from Domestic Violence Act 2005, monetary reliefs. It is with respect to monetary reliefs. So while disposing of an application under subsection 1 of section 12, the magistrate may direct the respondent to pay monetary relief to meet expenses incurred and losses suffered by aggrieved person and any child of aggrieved person as a result of domestic violence, and such relief may include. And next, so and so the section is like that. So now I filed a application under section 1 is you are filing a main petition under Domestic Violence Act, that is section 12. With that, you will be filing one application with that petition, saying that you want, ex parte interim maintenance. So that comes under section 23 of Domestic Violence Act. So under section 23, if you read, power to grant interim and ex parte orders. So in that petition which I filed, even before the notice was served to the respondent, the court ordered some of amount. I would say in that case, I guess both for mother and minor daughter, 5,000 each. The court had ordered. So this is under this Domestic Violence Act, you are again entitled for maintenance. Yeah. So monthly maintenance. So monthly, the husband is supposed to pay to wife. Okay. So this is now you can ask a question, sir. Section 24, there is one maintenance application filed. Section 125 of CRPC, there is one petition filed seeking maintenance. Again, the wife has filed another one petition under section 12 of DV Act. So simultaneously, she has filed 3 petitions seeking, one is application and 2 petitions seeking maintenance. So what will be the husband's condition? How will he pay everywhere? Be it under the MC petition, that is divorce petition, be it under section 125 criminal miscellaneous petition or domestic violence petition. For this, the answer is yes. The court, their family court can award maintenance amount there under MC petition. Again, the wife is entitled to get maintenance under section 125 of CRPC, that is criminal miscellaneous petition. Again, wife is entitled to get maintenance under section 12 of Domestic Violence Act. So all the state, if you read the statements and object of the act of all these 3, or if you read the object behind the law of all these 3, that is section 24 of Hindu Marriage Act, if you read section 125 of CRPC, if you read section 12 of Domestic Violence Act, the object is different. So the court has time and again, both Supreme Court as well as jurisdictional high courts have held that the wife is entitled to get maintenance in all these 3 petitions. Nothing stops us, nothing stops wife from not filing a petition if she has already filed MC petition, and if she is getting a maintenance under section 24, she can file this, provided she should prove her case with solid documents, that is evidence. So yes, this is regarding a brief conversation or brief discussion regarding divorce and maintenance law. So yeah, with respect to other topics, other associated topics of divorce and maintenance, we'll be having another session. Okay, and soon it will be organized by the organizer. And yes, if you have If you have any doubts, you can ask. So yes, they are posted in chat box. I will answer one by one. How is alumni calculated? Okay. Good question. Okay. What happens is, in a petition, you are a wife. You ask, I want alumni of 5 lakh. How will that be calculated? So it will be calculated on the basis of, one, you should provide assets and liabilities affidavit as I told. See, someone has in chat box, they have mentioned that husband filed wrong affidavit as per uh, Rajnish versus Neha judgment. See, aftermath of this Rajnish versus Neha judgment, it has become mandatory to file assets and liabilities. If you are filing petition under section 12 of Domestic Violence Act, if you are filing section 125 petition under CRPC, it is mandatory to file assets and liabilities aftermath of this Rajnish versus Neha judgment. So if in case, if you provide, say for example, if husband is drawing 1.5 lakh per month as salary, so in his assets and liabilities, he has mentioned only 40 to 50,000. So he has stated something false in his affidavit, right? Because in his affidavit, he swears on oath that whatever he has stated is true. He swears it before the notary. And if he files before the court, if it is on record, and if wife proves that whatever he has stated in assets and liabilities is wrong, whatever he has stated in affidavit is wrong, then the husband, the court can order for the husband, and it can send him to the jail. He may be behind bars. So while drafting assets and liabilities affidavit, we should be very careful when it comes to salary. Normally, 70 to 80% of assets and liabilities affidavit which are filed before family court are nearest to truth. Okay, they'll not take that risk of stating something false and vague. There is a risk in that assets and liabilities affidavit. You should be always true. Okay, so that is one thing. And how the maintenance will be calculated? The maintenance will be calculated taking various factors into consideration. They'll see whether wife is financially stable and independent to maintain herself. See the evidence produced by husband on record. They'll see husband side whether he is financially fit and stable to give maintenance to his wife. They'll consider again his financial aspects, his designation, his education, his societal status, his designation, his salary, his assets, in the sense properties. So taking these things into consideration, provided if wife is unable to maintain herself, uh, the court orders, the court arrives into a conclusion what amount of alimony or what amount of maintenance must be ordered by the court. This is how it is. And now recently we saw many posts on social media platforms saying that even if you're a coolie, you should pay maintenance amount to your wife. This is how the law is developed, maintenance law. So even if you're a person downtrodden, you are supposed to maintain your wife as a dutiful husband. So that's the present maintenance law jurisprudence which are uh, followed by family courts. Okay, this is how it is, and we'll go when the respondent husband never come into the witness box and never examined by court, only is fighting his case through his advocate, what to do, sir? So I didn't understand this question. You mean to say that the respondent, that is husband, never comes to the court and he has not come into the witness box, only is fighting his case through his advocate? What happens if the husband does not comes to the witness box? So that stage will be closed. The petitioner advocate says that, my lords, the respondent, that is RW, respondent witness, husband, he's not coming before this court for cross-examination. Kindly close this stage. Court will give few opportunities, 1, 2, 3, max 4, 5. Sixth time that stage will be closed and it will be posted for arguments. Does that stop respondent to enter into the witness box again? No. He can just file a recall and reopen application of that particular stage. If court takes 99.5, 99.99% of the recall and reopen applications will be allowed by the court, only in the interest of parties. Okay, so even if it does not comes to the witness box, if that stage is closed again, once he comes back, he can file the simple application. He can again be cross-examined by the advocate. Again, that's a thing which you will get to know if you are a practicing advocate, and once you start your practice, you will obviously get to know how these things work. Fine. So if wife is earning more, is she liable for maintenance filed by jobless husband? Yes. So this is a new law where a jobless husband can get maintenance from a wife, provided he should again prove that he is not financially stable, but wife is financially stable and she is earning so much of money. This is, rarest of the rare case which happens. Even if you ask me, in 1,000, one of the case might be like this, that the husband files petition, or he files maintenance application saying that he wants that maintenance amount, because respondent is that is the wife is financially stable, financially capable to pay him. He's jobless and he doesn't have anything. So that is the rarest of the rare case which we see. Okay, so that is one thing. And yes, you can withdraw domestic DV matter. Yeah, you can withdraw the case, or it could settle by mutual consent. See, you can't settle that by mutual consent, but you can withdraw the case, domestic violence case, which you have filed. But in most of the cases, if wife files DV petition against husband, rarest of the rare case, someone withdraws, but most of them, they won't withdraw, because one, they'll be receiving monthly monetary amount, that is maintenance amount. Second, they'll be asking, no, under section 12 of Domestic Violence Act, she can ask for whatever the pain and suffering which she has faced. So she'll be asking some amount for that. She can also ask for a residence. No, the husband cannot throw out from this from residence where wife is residing, or the wife can also ask to pay monthly rent amount from husband's pocket. So That is one aspect. Rather than financial independence of wife, any other ground to avoid alimony claims. Oh, yeah, there are other grounds also. As I told, see, it does not depend upon only wife's financial status. It depends upon our designation. It depends upon our assets which she is owning. I mean, if she has substantial amount of properties in her name, our societal status, everything matters. No, not only our financial, I mean, the salary aspect which she's drawing from her workplace, only that doesn't matter. Every other thing, as I told, that is of our societal status, that is our, designation, that is our properties which she has in her name. So everything matters. That is how you can, the husband can slowly slip from paying extra maintenance amount or paying exorbitant maintenance amount to wife. So, sure. So we'll end with this session and we'll be coming with new session with a very particular topic on divorce as well as maintenance. And we can also discuss about guardianship. We can also discuss about adoption because these are all subtopics under uh, the very big topic that is family law. These are the sub branches of family law, topic of guardianship, topic of, you know, adoption. Will come with particular new topics of divorce as well as maintenance. And so again, we'll meet. Thank you, Akshay. We'll end this session.
Yes, sir. Vaibhavi, please.
Thank you, sir, for sharing your legal insights and illuminating this session with your knowledge. And to all the participants active here, a special note of thanks to Akshay, sir, and the entire legal innovation team for their organizing efforts. Stay tuned and to fuel your intellect with engaging and electrifying sessions like this. Thank you, everyone.
Thank you, Vaibhavi. Thank you, Gagan, sir. And thank you, everyone. Up left.
Thank you.